Let's proceed.
Good morning, and may it please the Court. I'm Merritt Schnipper here on behalf of the defendant, Edward Denehy. On multiple levels, this case is about the jury's role as an intermediary between the accused and the power of the government. There's no question that the defendant in this case had the right to exclude the Springfield police from his property, or that he attempted to do so. The only question is whether that right and his assertion of it had any role to play at his trial. When this Court abrogated the common law right to resist an unlawful arrest, it did so because it found that the rights traditionally protected by self-help could instead be protected by legal process. The instruction requested by the defendant at trial is a necessary piece of that transition from self-help to judicial protection of the right to be free from unlawful government intrusions.
The instruction requested was very different from the model instruction that you've included in the papers, correct?
There is a difference, although I think at heart they're similar. The instruction requested by trial counsel focused exclusively on a description of the rights protected by the Fourth Amendment in Article 14 and the exceptions or the exigency rules. When I proposed my model instruction, thought that the Court should also inform about, when force may or may not be used, and basically just specifically frame the issue as one for consideration of the defendant's intent.
But the difference is that the one given to the judge did not do that. It was not clear what the jury was supposed to do with the instruction given that was proposed.
Well, I think it's true that the instruction did not say you should use this information for this specific purpose, but I also think it's not fair to say that the instruction was somehow suggesting that there was a justification element there. I mean, I think it was basically attempting to inform the jury about the lay of the social and legal landscape in which this interaction occurred. So as with many other sort of subsidiary fact instructions that help the jury assess sort of the ultimate question of fact they need to decide, this was one that would basically allow the jury to think about what was happening between these parties.
If one were to make the judgment that the instruction offered was incorrect or just not appropriate, are you suggesting that the judge had an obligation to deal with it herself anyway?
I do think she did, because I think there's really obviously very little case law on this question in the Commonwealth, but if you read Morera and if you read Gomes, I think that a logical implication of those cases is that the trial court is at a continuing obligation to assess how to best sort of affect the transition from self-help to judicial redress. There's civil remedies out there. There's obviously the exclusionary rule in possessory cases. There's bail laws and stuff like that, but in this case, we don't really have a way for a person who's charged with crimes arising out of a dispute with the police actually over an unlawful entry to have that, that really important legal issue considered in the context of the charges against him or her. So as a result, the person, I think the unfortunate outcome at this trial of the fact that such an instruction was not given was that this interaction between Mr. Denehy and the police was portrayed as though it were the equivalent of any other interaction between two people in which one allegedly made threats towards the other. And I don't think that that's a fair representation of what happened at trial, and I don't think that absent the instruction, the jury was really fully empowered to apply facts to the law because it didn't really understand what was going on between the parties, or at least it certainly could have used a much better understanding.
Are you saying that the jury didn't have any information before it to be able to see that what the police did was overstepping their bounds?
Well, what they had was argument from the parties about whether the police were overstepping their bounds. I mean, there certainly was some suggestions from defense counsel that police were overstepping their bounds. But I think what happened in the sort of the unfortunate imbalance in the evidence presented was that there were 3 police officer witnesses, each of whom at the solicitation of the prosecutor gave evidence that it's standard operating procedure to enter private property without a warrant in our work. We do this all the time. And then in closing argument, the Commonwealth is able to portray this dispute as a situation in which the police are just doing their job, and we have a citizen here who's getting in the way and causing all these problems. That's a quote from the prosecution's closing argument. Now, the defendant's witnesses, they don't have any experience with the law, and they don't have anyone there to tell them other than the judge, well, here's actually what was going on between these parties. I mean, counsel can argue, but I think it's different from having the judge explain sort of the underlying basis of the dispute.
No, you didn't bring a motion to suppress any of the statements that your client made to police, did you?
Yeah, I was not trial counsel,
Oh,
but
well,
trial
whoever
counsel
was
did
trial
not.
counsel did not.
She did not.
And could have done, right? I mean, because there were statements here that would have made it much harder for the Commonwealth to make
I agree.
its case.
Basically, there could have been sort of a voluntariness argument, if not a custodial argument. I mean, he was certainly standing on his own property when he made these alleged statements, so there wasn't a custodial aspect to it. But I think there could have been an argument to suppress them, and that was not made. That's correct.
One thing I'm not clear on, did the judge give the model instruction
On
on this point?
No.
No, she did not. I'm sorry. I drafted that myself as part of my submission to this
She
court.
didn't mention the Fourth Amendment or anything.
She did not mention the Fourth Amendment or Article 14, and she, in her margin notation, she simply said not within the province of the jury and not issues raised by the case, which I think that second comment is clearly not the case, just based on the record. But I think, yes, Justice Gantz. Well, I just think it's important when we look at Commonwealth v. Morera, which is really the only case from this court that's directly sort of on point in this area and is at this point 30 years old. You know, the court specifically says what we're doing because we live in a civilized society where self-help has become anachronistic. And we're doing this not because the underlying right that self-help is used to effect no longer exists, but there's a separate avenue and a more civilized avenue in which it can be realized. So, but the court also says we're aware of the gravity of the intrusion of this sort of case presents and the fury with which a person might justifiably react. And we're not going to expect a person to stand aside coolly while this type of intrusion occurs. Instead, we're going to, I believe the quote is, give allowance to the due infirmities of human nature. And really, that's what the defendant is asking for here. I mean, there's no denying, regardless of what the exact quote was, that he was reacting with fury, indignance, and rage to this intrusion. But there's also very little dispute about the fact that the police went way over their bounds. And I think to be able to portray this as a person getting in the way of police doing their job really distorted the playing field at trial.
Can I change the focus for a second?
Absolutely.
You argue that this is about the Rule 36.
Yes.
If I understand correctly, trial counsel basically waived any objection. She withdrew the motion, is that correct?
She did not withdraw the motion. I mean, there's a dispute between myself and my sister about whether she withdrew the motion. So there is a docket entry that says withdrawn. At the transcript of those hearings, the word withdrawn is never said. There's no filing that says withdrawn. My affidavit in support of my the defense counsel's affidavit that I submitted in support of my motion to clarify the record, she clarifies I did not intend to withdraw this motion. I don't know if anyone here, had ever worked with Judge Leroy, but he kept things moving fast, and he was really a let's get things done type of judge. And what happened is basically she brought her motion. He basically says, this is going to take a while. We've got a trial date. What's going on? And she says, well, then I guess I'm going to need a new trial date. I don't read that as withdrawing the motion because there's certainly no point to putting the effort into cataloging the dates, bringing the motion, and then immediately at the first sign of resistance, which obviously will come to a Rule 36 motion, withdrawing it.
I think there's something further on in the transcript after the quote by the Commonwealth that suggests that counsel at least believed that she hadn't withdrawn anything. I can't remember what it is.
Certainly that Attorney Robert, defense counsel, did. There's a dispute, and I think the record is unclear as it often ends up being in the district court.
Mm-hmm.
So, but okay, put that for a minute to the side. Your position here, anyway, is, I take it, that at the very least, the however many days there are between when the dismissal without prejudice
Right, that was May 5th.
and the filing of the new complaint.
Yeah, or the arraignment date, which is August 20th, so that's a 99-day span there.
That's where your focus is.
I think that is one of the two pivotal periods in the Rule 36 question before this court. I mean, certainly the question of whether when a defendant moves to dismiss a complaint and just moves to dismiss on the basis of Commonwealth failure to appear ready for trial, and the Commonwealth takes its time to recomplain, certainly that's not excluded under the plain language of the rule, which talks about dismissal by the Commonwealth. It's also not really, it shouldn't be excluded under the spirit of the rule, which is about sort of encouraging judges to oversee the Commonwealth's primary responsibility for bringing matters timely to trial.
So if the Commonwealth had on May 5th, did you say? Whatever.
Yes.
Had null prost and the judge had accepted it, you'd have a different argument?
Well, I wouldn't have much of an argument.
Wouldn't
to
have
be
any
frank,
argument,
because
right?
the
It's-
letter of the
so
rule.
your argument is basically that the judge's dismissal is different from a null pros.
Right, and I'm not arguing that it's qualitatively different because it's a judicial dismissal. I mean, it is, but the real reason it's qualitatively different is, A, that the Commonwealth, when it null process, is taking a step in the interest of justice. That's not what it was doing here. And the second reason is that the dismissal itself was the consequence of other Rule 636 violations, or at least of other periods that should not be excluded by the Commonwealth, because twice, on both February 26th and April 4th, before May 5th, the Commonwealth had failed to appear with its police officer
So,
witness
so
for
your,
trial.
your position is that as of May 5th, the Rule 36 had run anyway. Is that right?
No, not that it had fully expired at that point, but that though that May 5th, was sort of the culmination of a since February 26th period that was also not excludable because there was a Commonwealth witness who was not unavailable under the meaning of the rule.
Okay.
And the defendant is put in a very strange position is if he stands by while a continuance is granted because the Commonwealth's witness is not prepared, then he's held to have acquiesced. If he objects, he's not, but if he objects too much and affects a dismissal and relief, then he is then seen to be acquiescing or somehow gaining a benefit from that when he's really what he's doing is fighting against the Commonwealth's delays. So I think it's really just the purposes of the rule are not served by excluding that interim period.
If I can go back to the first issue, is a police officer reasonably in fear if the threat is conditional in the sense that if the homeowner says, if you do something which you and I know to be illegal, that is to enter this home without a warrant, then I will sick my dog on you.
I think, sorry.
The question is, would a police officer reasonably be put in fear by a statement if a reasonable police officer would have recognized that the conduct which would trigger the use of force is illegal?
I say no, because I say that if a police officer says, well, all I need to do is observe the law and respect Mr. Denehy's property rights, then I'm not in any danger of an imminent battery, then there's no reasonableness to that fear. I don't believe that the officer saying, well, listen, property owner, regardless of what you think, I'm going to assert my rights to come on your property, and thus the fact that you're screaming at the top of your lungs to try to prevent me from coming on allows me to be placed reasonably in fear. I don't think we can take it that far. I mean, the idea of an immediate battery presupposes that there's no barrier between the purported victim and the potential execution of that battery. And here there is both a physical barrier, there's a 4 or 5 foot fence between the parties, and there's also sort of a conceptual barrier that the officer has to do to take that sort of next violative step in order to be placing himself in the conditional danger. So, I mean, there were different ways that this could have been charged if indeed it should have been charged at all. But, there's threatening to commit a crime or other types of lesser.
Well, I take it if he'd had a gun and said, if you come onto my property, I'll shoot you. Would that be different or the same as a dog?
I think it's a different analysis because there's the barrier that existed, although there's still the conditional issue, but the barrier, the physical barrier that is a real consideration in this case wouldn't be there because obviously the gun is not impeded by the physical barrier in the way the dog is.
Big dog here.
It's a Great Dane. I mean, obviously the record is not, this is it's an elderly Great Dane that's since passed away, but there's a real question here as well. Although the dog is large, it's certainly not an attack dog breed, but it's a very large dog, and he's standing there next to his large dog behind a fence, and he's saying, if you come on my property, I'm going to set my dog on you, but there's nothing indicating that the dog is either aggressive in any way or indeed even responsive to the defendant's commands. There are no commands given, and yet
But isn't there evidence the dog was barking? Somebody testified the dog.
Yes, there's evidence the dog was barking after he was pepper sprayed.
Oh,
Or after they crossed the fence, crossed through the
The pepper
fence.
spraying and the crossing of the fence kind of was a simultaneous.
If the officers had a warrant and the defendant said, if you enter my property, I'm going to sick my dog on you, would that have been an assault by means of a dangerous weapon?
I think that there would certainly have been sufficient evidence under those circumstances, but I mean, that really takes me back to my jury instruction question because the real issue is who, between the understandings of the parties, who is in the right to take that action. And,
Of course, the problem is that it seems like you're inviting the police and citizens to resolve this by fisticuffs before they ever set foot into a courtroom. when there are adequate remedies, such as a motion to suppress or a 1983 action for any infraction by a police officer.
Well, I'm certainly not intending to invite fisticuffs. What I really
But
am-
isn't that the practical result of what you're suggesting?
Well, I don't think it is. I think the practical result, as with the exclusionary rule's existence, is the hesitation at the threshold of police when they know they may be entering in violation of someone's rights. And they know this is another aspect in which a judicial remedy may be available. I mean, to look to 1983, it exists, but it's hardly, I think, an effective remedy for many people, including Mr. Denehy, who doesn't suffer a lot of actual damages and is going to have to go out and solicit an attorney to take his case, in the hope of recovering legal fees down the line. So I think that, did he have the right to bring a 1983 case? Of course he did. But I think to hold that out as sort of an adequate substitute for the instruction I'm asking for is, they're not mutually exclusive, and indeed they support each other because there's no need in a lot of cases. And I spoke to Mr. Denehy. He had no desire to sue the government. All he wanted to do was be able to basically present his own case.
Counsel, we're going to have to leave it there. Your time is up.
Thank you very much.
May it please the court, my name is Deborah Alstrom. I'm an assistant district attorney in Hampden County. Before I address any of the other issues, I'd just like to address the Rule 36 issue because, of course, it could be determinative of the case. I think the record is clear, and dispute this with my brother, that defense counsel did withdraw her motion to dismiss. The testimony, not only is there the notation in the clerk's record, but if you look at the testimony that occurred when the motion to dismiss was being heard, the judge readdresses the motion and says something to the effect of, you are here, you have brought a Rule 36 motion. Why are you asking for another date? You were moving on Rule 36. And her response is, yeah, well, now, and he says, now you're asking for a continuance. She says, sometimes strategy changes. She doesn't preserve her right to raise the motion to dismiss at a later date. There are subsequent court dates, and the motion is never readdressed again. As a matter of fact, it's continued.
On appeal, the defendant has said, well, if she did, it's ineffective assistance, right?
He made that statement, yes.
So somewhere or another, we're going to have to deal with whether Rule 36 ran or didn't run.
That's
it
correct.
seems to me. And
And-
why should we treat a dismissal by the judge without prejudice the same way that a null pros should be treated?
Because essentially it is the same thing.
It's not.
Well, Rule 36 says that if a case is dismissed in good faith by the prosecutor, then the time doesn't count. However, Rule 36 also says that time doesn't count in instances where the defendant is responsible for, acquiesces to, or benefits from a period of time. And I would suggest to the court that all three of those apply to a situation where the judge dismisses the case on
But
the motion
the
of
judge
counsel.
dismissed the case because the Commonwealth had failed to show up with its witnesses on multiple occasions.
And as a result.
As the
the
result, the defendant benefited?
The
So
def-
therefore, that when they bring the
Benefited
charges
because-
99 days later, the time doesn't count? I don't
He
understand.
benefited because he had no criminal charges hanging over his head at that time. And if you look at the cases that address this in terms of a constitutional right to trial, that's the way it's treated. The benefit of the time not being counted is the fact that the defendant is not subject to criminal prosecution during that period of time.
So you would say it would be okay if the judge expressly dismisses, but without prejudice, because the Commonwealth has inexcusably not come forward with its witnesses. And then on the fifth year, right before the statute of limitation runs, 2 years later or 3 years later, initiates a complaint. That's fine because the defendant has benefited from 2 or 3 years of not having this charge against him?
That time would not count in other instances, as in the Butler cases. The first Butler case from '07 was brought under Rule 36, and the second Butler case was this year, 2013, and that was a constitutional right to speedy trial. And in both those, I believe there was a 10-year period overall.
But didn't the Commonwealth null pros in that case?
The Commonwealth did null pros.
Because it didn't have it didn't have the witness?
They could not find the witnesses in that case.
That's a little different, isn't it?
Well, it's a distinction without a difference, I believe, Your Honor, because the cases, including, I believe it's U.S. versus Loudhawk, say that it's because the defendant is not under the cloud of the prosecution. In many cases, they're held on bail and then released. In this case, there's no bail, obviously, but at the same time, he was a free man for that period of time without fear of prosecution, and the Commonwealth did not necessarily have to recomplain the complaint. I mean, maybe they could have decided not to. But I think that the underlying fairness is the same in both cases, and I think it does comply with those considerations in Rule 36 for continuances. The three controversial time periods that I see in this Rule 36 situation. One was during a period of time when I think there were 20 days when the defendant was without counsel. And Commonwealth versus Marable, if that's how you pronounce it, found that that did inure to the benefit of the defendant and should not be counted. Then there was another period of time which the clerk notes that the judge did not hold against the Commonwealth. I think it was a period of 57 days, and I think that should not be counted as well. And in addition to the period of time between the dismissal and the new complaint.
Can I switch gears? Do you mind?
Pardon me?
Could I switch gears and keep
You
you
certainly may.
still off your argument? I apologize, but I do have this question. Turning to the question of restitution, I'm puzzled as to what how to justify, put aside the Southern Union, how should restitution be attached to the, if I understand correctly, assault with a dangerous weapon? Because you had a fine on the disorderly conduct, and you had an acquittal on the assault and battery on a police officer. So it can only be the assault with a dangerous weapon, correct?
Correct.
Breaking glasses on an assault with a dangerous weapon, which by its definition doesn't involve I don't understand how that justifies a restitution order.
Well, I would look to the cases, as in McIntyre, that there is a relationship, a nexus between the activities, if you will, of October 20th, 2008, and the fact that the glasses are broken because of the defendant's tumultuous behavior and the assault and battery. There was evidence of an assault and battery, although the jury...
But he was acquitted.
He was acquitted of that.
You can't use
but
that.
It's all part of the same series of activities. And as a result of that, I think there is a connection between the activities on that day and the restitution. And that's what the cases say. McIntyre was, the defendant kicked the car, which was not related at all to the assault and battery, which was the stabbing. But the court still found that there was a nexus because it was part and parcel of the whole series of activities. I think the case is Palmer P. It's a juvenile court case. The defendant was charged with both larceny and breaking and entering. And he was found not guilty of the larceny. Yes, not guilty of the larceny. He was still assessed restitution on the breaking and entering because it was instrumental, if you will, in obtaining the stolen goods, even though he was found not guilty of obtaining the actual
The restitution
stolen goods.
was for the stolen goods?
Yes. So I would suggest there is the necessary nexus between what happened and the restitution that occurred. And in case this court has a question about the due process, I think that the defendant in this case waived his right to a hearing. There is evidence also in the testimony from that hearing, from the motion to dismiss, that the prosecutor had a receipt for the amount of glasses because, as my brother said about Judge Leroy tried to get the prosecutor to dismiss the case on payment of the $264 in restitution. So it would be reasonable to infer that during this long period of time, the prosecutor and defense counsel spoke about the receipt for the glasses and the value of the glasses, and that the defendant waived any right to object to that. And he indeed made no objection on the record.
You've said that the restitution is not really part of the criminal sanction and therefore doesn't fall within the Apprendi sort of category of things that must be determined.
That is my argument, Your Honor. I think if you go back, traditionally in Massachusetts especially, the judge has a right to impose restitution under the statute that gives him power to impose conditions of probation.
I understand that, but let me ask you this hypothetical, which comes to mind. Let's assume that an individual is charged with malicious destruction of property over $250. Jury comes back guilty, malicious destruction of property under $250. Can the court then say, well, but there was $1,000 of destruction here, so I'm going to impose restitution of $1,000?
I think, Your Honor, if it's proven by a preponderance of the evidence in
As part of the
hearing,
sentencing process.
as part of the sentencing process, and the defendant has an opportunity to rebut that, I think it could be imposed.
Okay.
In general, the Apprendi line of cases is concerned with the maximum punishment that a defendant can obtain. And that would apply to both incarceration and fines, because they're both defined by statute as punishments. And there's a maximum and a minimum in each instance. And that's what the cases have been addressing. Restitution has no maximum. It has no minimum. It is completely discretionary, at least in our courts. The federal court is a little different, but it is discretionary. And as a result, the Apprendi line of cases do not apply. And all of the cases along the line have said that. Going back in Massachusetts, Commonwealth v. Non in 1985 determined that a defendant did not need a jury trial in terms of the restitution orders. And they cited to the finding of the United States versus Satterfield, which was a 1984 case, which considered the constitutionality of the Victim Witness Protection Act, and that established that restitution would be obtained, that a jury trial was not necessary.
This
for
is all
obtaining
pre-Apprendi. I mean,
that is pre-Apprendi, and then you do have Apprendi, which established that any fact that added to the maximum punishment that a defendant could obtain had to be found by the jury. And that traditionally had been the case in Massachusetts even. But after Apprendi, you have United States versus Milkowitz, and I note that because it's a First Circuit case. It was from 2006, and the court in Milkowitz held that the restitution order did not violate the defendant's Sixth Amendment right to a jury trial because the judicial fact findings on the amount of the loss did not increase the maximum punishment that was allowed as a result of the jury found facts. So these cases have completely focused on the statutory punishment that a defendant may get as a result, and that anything that increases the maximum has to be found by the jury, whether it's the fines in Apprendi, the fines in Southern Union, or the actual punishment in Apprendi. In Apprendi, it was whether the crime occurred as a result of racial bias.
Attorney Ostrom, you're about to run out of time, but I wanted to ask you a question about the Fourth Amendment. And I wonder if there is a line to be drawn, or if you would draw a line. In particular, I'm thinking of a situation where police enter a house with a search warrant looking for drugs, and then they start pulling out drawers, throwing them on the floor, tipping over furniture. They may even have an axe with them and start chopping holes in walls looking for the drugs. Situations that occur in our case law. In circumstances like that, would a citizen have a right to use force to stop a police officer from that
Your Honor, I think
level of
Marrera-
intrusion?
I think Marrera speaks directly to that self-help is not available.
At all?
At all. And actually, in the case of Commonwealth versus Kaloji, it was a 2007 case, the appeals court said that would immunize, that the prior bad acts of the police would immunize the police from any subsequent criminal acts, including murder. And I would suggest that the resort is to the courts.
And if I could, I'm sorry, Chief, if you would answer the question I asked of your brother with regard to a conditional threat. Is a police officer reasonably in fear if the threat is conditioned upon conduct which the police officer would know to be illegal?
And I thought that was an excellent question. I'm not sure it would be reasonable if it's conditional, although his intent, this officer's intent, was obviously to go back into the property, and he took the threat as a threat.
Right, but I guess the question is, was he reasonable?
Well, the
in
question
doing
is really,
that?
was he then reasonable to go into the property? And I can't answer that.
And again, I guess the question then is, should the jury then have had to answer that question before they found him guilty?
Well, just in regards to that, real quick, there was a lot of testimony in regards to privacy rights and private property and the warrant process. There was actual testimony during the course of the trial via questions by defense counsel.
Counsel, thank you very much.
Thank you, Your Honors.